The Indian judiciary is one of the key pillars of the country's democratic system, entrusted with upholding the rule of law and ensuring justice for all citizens. Here are some key points about the Indian judiciary. Structure. The judiciary in India is a hierarchical system with the Supreme Court at the top, followed by high courts at the state level, and subordinate courts such as district courts, sessions courts, and magistrate courts at the district level. 2. Independence. The Indian judiciary is known for its independence, with judges appointed through a rigorous process that aims to ensure impartiality and integrity. The Constitution of India provides for the independence of the judiciary and insulates judges from external influences. 3. Jurisdiction. The Supreme Court of India has original, appellate, and advisory jurisdiction. It hears appeals from high courts as well as certain cases directly from lower courts. High courts have jurisdiction over a particular state or group of states, while subordinate courts handle cases at the district level. 4. Judicial activism. Indian judiciary is often seen as proactive in protecting fundamental rights and ensuring social justice. It has taken suo motu cognizance of various issues affecting society, including environmental degradation, corruption, and human rights violations. Five. Public interest litigation. Indian judiciary has been instrumental in expanding the scope of public interest litigation, allowing individuals and organizations to file cases on behalf of those whose rights are violated, even if they are not directly affected by the issue. 6. Backlog of cases. One of the significant challenges facing the Indian judiciary is the backlog of cases, leading to delays in the dispensation of justice. Efforts are being made to address this issue through measures like court modernization, increasing the number of judges, and promoting alternative dispute resolution mechanisms. 7. Technology adoption. There has been a gradual adoption of technology in the Indian judiciary to streamline processes, improve transparency, and facilitate access to justice. Initiatives like e-courts and online case management systems aim to make the legal process more efficient. 8. Judicial reforms. There have been ongoing discussions and debates regarding judicial reforms in India, including issues related to the appointment process of judges, accountability, and judicial activism. Efforts are being made to bring about reforms that enhance the efficiency and effectiveness of the judiciary. Overall, the Indian judiciary plays a crucial role in upholding the principles of justice, equality, and the rule of law in the country, despite facing various challenges. Introduction to the independence of the Indian judiciary. What is judicial independence? The ability of the judiciary to function without undue influence from the executive or legislative branches of government. Ensures fair and impartial administration of justice. Importance of judicial independence. Maintains the rule of law. Protects individual rights. Promotes checks and balances in government. Independence of judiciary and provisions of the Supreme Court. For a federation, it is essential that the judiciary should be independent. There must be provision of Supreme Court to settle federal disputes. It should be custodian of the Constitution. If any law contravenes any provision of the Constitution, the apex court, i.e. the Supreme Court of India, can declare it as null and void or unconstitutional. In order to ensure the impartiality of the judiciary, the Chief Justice or the judges cannot be removed by the executive, nor their salaries can be curtailed by the Parliament. Supreme Court of India, an introduction. When you read the Constitution of India, you will come to know that it is characterized as a federal constitution. By federal constitution we mean a written constitution which provides the division of powers between central and the state governments. It is the supreme law of the land. But the language of the Constitution is very complex, as its meaning is likely to be interpreted by different authorities at different times in different manners. Hence, it is natural that dispute might arise between the center and its constituent units regarding their respective powers. Therefore, in order to maintain the supremacy of the Constitution, there has to be an independent and impartial authority which will decide disputes between the center and the states inter se. This function has been entrusted upon the Supreme Court of India. The Constitution of India has provided a single integrated and unified judicial system for the whole country. It means that for the entire country, there is one unified judicial system, one hierarchy of courts with the Supreme Court as the highest or the apex court. It is also the highest and the final interpreter of the Constitution and the general law of the land. Composition and organization of the Supreme Court. The Supreme Court of India consists of a Chief Justice and 33 other judges. The Parliament may increase this number by law. Originally, the total number of judges was 7, but in 1977, it was increased to 17, and in 1986 to 25, excluding the Chief Justice. Later in 2009, it was fixed at 31 judges including the Chief Justice of India. Under Article 124 subsection 2, Supreme Court judges are to be appointed by the President, after consultation with such judges of the Supreme Court and of the High Courts as the President may deem necessary. The provision in the article says that in the case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall always be consulted. It is obligatory for the government in which it has to consult the Chief Justice and other judges. Significantly, the appointment is not required to be made in consultation but only after consultation, and the opinion should be in written. In actual practice, after receiving the opinion of the Chief Justice, the Cabinet deliberates on the matter and advises the President in regard to the persons to be appointed. The President acts on the advice. The Chief Justice has to consult 4 senior-most judges of the Supreme Court, and if 2 of the 4 disagree on some name, it cannot be recommended. In fact, decisions are to be taken by consensus where the Chief Justice and at least 3 of the 4 judges agree. In case of the Chief Justice, the senior-most judge is usually appointed. The practice has virtually been transformed into a convention and is followed by the executive without any exception. But on April 25, 1973, the convention was broken when the government appointed Justice A. N. Roy superseding 3 of his senior colleagues. The government's action has been criticized of arbitrariness and undermining the independence and impartiality of the judiciary. To avoid such types of controversies, a bill was introduced in the Lok Sabha by the National Front government for setting up a National Judicial Commission in the year 1990 by the then Law Minister Dinesh Goswami, empowering the President to constitute a high-level judicial commission for making recommendation for the appointment of the judges to the Supreme Court, Chief Justice of High Courts, and to the transfer of judges from one high court to another. But the constitutional amendment bill lapsed consequently upon the dissolution of the Lok Sabha. Powers and jurisdiction of the Supreme Court. Article 129 provides that the Supreme Court shall be a court of record and shall have all powers of such a court. Being the highest court of the land, its proceedings, acts, and decisions are kept on record for perpetual memory and for presentation as evidence, in support of the law. Being a court of record, it implies that its records can be used as evidence and cannot be questioned for their authenticity in any court. Court of record also means that it can punish for its own contempt. But this is a summary power, used rarely and under pressing circumstances. It does not restrict genuine and well-intentioned criticism of court and its functioning. Fair and reasonable criticism of judicial acts in the interest of public good does not constitute the contempt. Jurisdiction. The Supreme Court has the following jurisdictions. Original jurisdiction. Original jurisdiction means the power to hear and determine a dispute in the first instance. The Supreme Court has been given exclusive original jurisdiction which extends to disputes between the Government of India and one or more states. Between the Government of India and one or more states on one side and one or more states on the other. Between 2 or more states. Jurisdiction. The Supreme Court in its original jurisdiction cannot entertain any suits brought by individuals against the Government of India. The dispute relating to the original jurisdiction of the court must involve a question of law or fact on which the existence of legal right depends. This means that the court has no jurisdiction in matters of political nature. However, this jurisdiction shall not extend to a dispute arising out of a treaty, agreement etc. which is in operation and excludes such jurisdiction. Article 131. The jurisdiction of Supreme Court also excludes in interstate water disputes. Article 262. Matters referred to the Finance Commission. Article 280. An adjustment of certain expenses and pensions between the Union and States. Article 290. If any dispute is to be brought before the Supreme Court, it must involve a question of law on which the legal right depends. Under Article 139a, the Supreme Court may transfer to itself cases from one or more high courts if these involve questions of law or of great importance. The Supreme Court may transfer cases from one high court to another in the interest of justice. The original jurisdiction of the Supreme Court also extends to cases of violation of the fundamental rights of individuals, and the court can issue several writs for the enforcement of these rights. Article 32. It is a unique feature of our Constitution that in principle, any individual can straightway approach the highest court in case of violation of his/her fundamental rights. Appellate jurisdiction. The appellate jurisdiction of the Supreme Court extends to civil, criminal, and constitutional matters. In a civil matter, an appeal lies to the Supreme Court from any judgment, decree or final order of a high court if the high court certifies under Article 134a that a substantial question of law of general importance is involved and the matter needs to be decided by the Supreme Court. The High Court grants certificate only where there have been exceptional circumstances where substantial and grave injustice has been done. Thus, a certificate cannot be granted by the High Court on mere question of fact, where no substantial question of law is involved. In criminal cases, an appeal to the Supreme Court shall if the High Court has reversed an order of acquittal of an accused person and sentenced him to death, has withdrawn for trial before itself any case from any subordinate court to its authority and has in such trial convicted the accused person and sentenced him to death. It is to be noted that before the commencement of the Constitution, there was a federal court in India. It was created by the Government of India Act 1935 and has been abolished by the Constitution of Independent India. Article 135 was included in the Constitution to enable the Supreme Court to exercise jurisdiction in respect of matters where the federal court had the jurisdiction. Under Article 136, the Supreme Court, by its own, may grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. These powers of the Supreme Court to grant special leave to appeal are far wider than the High Court. The Supreme Court can grant special leave against judgments of any court or tribunal in the territory, except the military courts, and in any type of cases, criminal or revenue. But the Supreme Court has itself said that it will grant special leave to appeal only in cases where there has been gross miscarriage of justice or where the High Court or tribunal is found to have been wrong in law. So, it is not taken as a usual practice. A tribunal is a body of authority, although not a court, having all the attributes of a court, which has judicial powers to adjudicate on the question of law or fact affecting the rights to citizens in a judicial manner. Article 137 provides for the Supreme Court having the power to review its own judgments and orders. The Supreme Court has held that a judgment of the apex court of the land is final. A review of such a judgment is an exceptional phenomenon, permitted only where a grave error is made out. Advisory functions of the judiciary. Article 143 of the Constitution confers upon the Supreme Court the advisory jurisdiction. The President may seek opinion of the Supreme Court on any question of law or fact of public importance on which he/she thinks it is expedient to obtain such an opinion. On such references from the President, the Supreme Court may report to him/her its opinion thereon. The opinion is only advisory, which the President is free to follow or not to follow. Also, it depends upon the Supreme Court whether to give opinion or not depending on the case. Article 139 lays down that Parliament may confer on the Supreme Court power to issue directions, orders, or writs in matters not already covered under Article 32. Under Article 140, Parliament may supplement the powers of the Supreme Court to enable it to perform effectively the functions placed upon it under the Constitution. Law declared by the Supreme Court is binding on all courts in India under Article 141. Article 142 provides that the Supreme Court in exercise of its jurisdiction may pass such decrees or orders as necessary for doing complete justice. The decree or order made by the court shall be enforceable throughout the territory of India in such a manner as prescribed by the Parliament. Until provision is made by the Parliament, the orders of the court will be enforced in the manner prescribed by the President. For purpose of giving effect to the directions and decisions of the Supreme Court, all authorities, civil and judicial, in the territory of India have been made subordinate to the authority of the Supreme Court, Article 144. The Supreme Court may from time to time, and with the approval of the President, make rules for regulating generally the practice and procedure of the court. The public interest litigation, PIL, is a strategic arm of the legal aid movement which is intended to bring justice within the reach of the poor masses. It is a device to provide justice to those who individually are not in a position to have access to the courts. It was initiated for the benefit of that class of people, who had been denied their constitutional and legal rights because of their socio-economic disabilities. The aim of public interest litigation is to give the common people of this country access to the courts to obtain legal redress. According to the traditional Anglo-Saxon concept of locus standi, only the person whose rights were violated could seek for judicial redress. No one could file a petition in the court on his behalf. This doctrine was evolved in an era when the courts were mainly concerned with the rights of the individual. Therefore, it has been felt that traditional interpretation of locus standi should be changed to bring justice within the reach of the poor masses. According to the new interpretation of this doctrine, when the rights of an individual or a class of persons are violated and if by the reasons of poverty or disability they cannot approach the court themselves, any public-spirited person or institution, acting in good faith can move to the court for the judicial redress. In a landmark case of S.P. Gupta v. Union of India, popularly called the Judge's Case, Justice P.N. Bhagwati said that major impediment in bringing the problems of underprivileged before the courts was the traditional rule of locus standi. Rejecting the notion, he held that any public-spirited individual can move the court in case where the person concerned seeks judicial redress, provided that the person is acting in the interest of public and not for personal gain, private profit, political motivation, or other considerations. Thus, the court has now done away with orthodox bar of locus standi and now it can be approached even by a letter which can be treated by the court as writ petition. The first reported case of public interest litigation was in 1979, which has focused on the inhuman conditions of prisons and under trial prisoners. In Husainara Khatun v. State of Bihar, a public interest litigation was filed by an advocate on the basis of a news report highlighting the plight of thousands of under-trial prisoners languishing in various jails. It had led to a chain of proceedings, resulting in the release of over 40,000 under-trial prisoners. After this case, the Supreme Court has defined the right to speedy justice as a basic fundamental right which has been denied to the prisoners. But still, there were many who were at the whims of the legal and judicial authorities and who have paid a lot than which is expected from them. The Supreme Court has developed a compensatory jurisprudence to provide an amnesty for those who were victimized by justice-providing authorities. The compensatory jurisprudence was most clearly articulated by the court in 1993 in Nilabati Bira v. State of Orissa, in response to a public interest litigation alleging death of a man of 22 years of age in police custody. The court evolved the principle of public law doctrine of compensation for violation of rights. According to this doctrine, it is the liability of the state for violation of rights. In this case, the court awarded rupees 150,000 to the mother of the man as compensation for custodial death. Similarly, in Bandhwa Mukti Morcha vs. Union of India, case one organization dedicated to the cause of release of bonded laborers informed the Supreme Court through a letter that they conducted a survey of the stone quarries situated in Faridabad district of the state of Haryana and found that there were a large number of laborers working in these stone quarries under inhuman and intolerable conditions, and many of them were bonded laborers. The petition requested for a writ to be issued in the view to end the misery, suffering and helplessness of these laborers. The Supreme Court treated the letter as a writ petition and appointed a commission of inquiry and ordered the release and rehabilitation of all bonded laborers. Hence, public interest litigation has become the sole instrument of social revolution. Judicial activism. The Supreme Court has now realized its proper role in a welfare state, and it is using this new strategy not only for helping the poor for enforcing their fundamental rights but for the transformation of the whole society is ordered for a crime-free society. The Supreme Court's role in making up for inefficiency of the legislature and the executive is commendable. This is the evolving judicial activism of the higher courts. Judicial activism is a layman's term for the role of judiciary in initiating the policies to dispense justice. It is usually through the public interest litigation, but the Supreme Court from time to time has given directions, passed writs and issued orders to redress the injustice either on the request or by its own. Nevertheless, judicial activism has been under constant criticism from other two organs of the government, the executive and the legislature. Though it emerged only as a result of their inefficiency or lukewarm efforts to provide justice, even then they target judiciary on the legal grounds of exceeding its arena. Standing apart of the criticism, it is the people who have to decide that what is wrong and what is right, and when it is the question of providing justice, the technicalities should not come in the way to foster justice. Judiciary has to act if and when time comes and other institutions failed on their respective parts. Judicial review. Judicial review is power of the courts to examine constitutional validity of an executive or legislative action. Power of judicial review originated from USA in Marbury v. Madison was the first Supreme Court case where the court asserted its authority for judicial review to strike down a law as unconstitutional. At the end of his opinion in this decision, Chief Justice John Marshall maintained that the Supreme Court's responsibility to overturn unconstitutional legislation was a necessary consequence of their sworn oath of office to uphold the Constitution as instructed in Article 6 of the Constitution. Judicial review has two prime functions: 1. Legitimizing government action, and 2. To protect the Constitution against any undue encroachment by the government. The most distinctive feature of the work of United States Supreme Court is its power of judicial review. As guardian of the Constitution, the Supreme Court has to review the laws and executive orders to ensure that they do not violate the Constitution of the country and the valid laws passed by the Congress. Can the preamble be amended? One of the controversies about the preamble is as to whether it is a part of the Constitution or not. In the Barabari Union case year 1960, the Supreme Court said that the preamble shows the general purposes behind the several provisions in the Constitution, and is thus a key to the minds of the makers of the Constitution. Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objectives enshrined in the preamble. Despite this recognition of the significance of the preamble, the Supreme Court specifically opined that preamble is not a part of the Constitution. In the Kesavananda Bharti case year 1973, the Supreme Court rejected the earlier opinion and held that preamble is a part of the Constitution. It observed that the preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. Landmark cases. Kesavananda Bharti v. State of Kerala. The 13-judge constitutional bench of the Supreme Court deliberated on the limitations, if any, of the powers of the elected representatives of the people and the nature of fundamental rights of an individual. In a sharply divided verdict, by a margin of 7-6, the court held that while the Parliament has wide powers, it did not have the power to destroy or emasculate the basic elements or fundamental features of the Constitution. The Casavananda judgment also defined the extent to which Parliament could restrict property rights, in pursuit of land reform and the redistribution of large land holdings to cultivators, overruling previous decisions that suggested that the right to property could not be restricted. The case was a culmination of a series of cases relating to limitations to the power to amend the Indian Constitution. Golak Nath vs. State of Punjab, year 1967. The Golak Nath vs. State of Punjab, year 1967 case is a landmark decision by the Supreme Court of India regarding the amendment of the Constitution. Here is a summary of the case. Background. The case was brought by the Golak Nath family, who challenged the Punjab government's attempt to impose restrictions on their lands under the Punjab Security of Land Tenures Act, 1953. They argued that the act violated their fundamental rights guaranteed by the Constitution of India. Key issues. The primary issue was whether Parliament had the power to amend fundamental rights under Part 3 of the Constitution. Supreme Court's decision. Amendment power. The Supreme Court held that Parliament could not amend fundamental rights. It declared that fundamental rights are immutable and cannot be abridged or taken away by amending the Constitution. Doctrine of prospective overruling. The court introduced the doctrine of prospective overruling, stating that its decision would not apply retroactively but would only affect future amendments. Article 368 interpretation. The court interpreted Article 368, which deals with the power of Parliament to amend the Constitution, and concluded that it did not include the power to amend fundamental rights. Impact. The Golak Nath case significantly curtailed the Parliament's power to amend the Constitution, especially with regard to fundamental rights. The decision was later overturned by the 24th Amendment and the Kesvanand Bharti case, year 1973. Where the Supreme Court ruled that the Parliament could amend any part of the Constitution, but it could not amend its basic structure. Challenges to judicial independence. Political pressure. Influence in appointments, instances where the executive branch attempts to influence the appointment of judges, potentially compromising impartiality. Examples of controversies surrounding the collegium system and executive interference. Judicial decisions. Efforts by political entities to sway judicial decisions through media campaigns or other means. High-profile cases where political pressure may have played a role in judicial outcomes. 2 delays in justice. Case backlog. A significant number of pending cases in courts, leading to delayed justice. Statistics highlighting the extent of the backlog in various levels of the judiciary. Public perception of trust. Perceived corruption, instances of corruption within the judiciary, undermining public confidence. High-profile cases of judicial misconduct or corruption. Media influence, the role of media in shaping public opinion about the judiciary. Instances where media coverage has impacted the perception of judicial independence and impartiality. Judicial accountability versus independence. Balancing act, the challenge of ensuring judicial accountability without undermining independence. Mechanisms in place for judicial accountability, such as the impeachment process, and their effectiveness. Judicial overreach, instances where the judiciary has been accused of overstepping its boundaries and encroaching on the domains of the executive or legislature. Examples of landmark cases where judicial overreach was alleged. Infrastructure and resources. Lack of adequate resources. Inadequate infrastructure, staffing, and financial resources affecting the judiciary's functioning. Examples of courts operating with insufficient resources. Technology and modernization. Challenges in implementing technological advancements to improve efficiency. Initiatives like e-courts and their current status and impact. External pressures and threats. Threats to judges, instances of threats or attacks on judges, compromising their ability to deliver impartial justice. Examples of judges facing intimidation or violence. Security measures, the adequacy of security measures for judges and court premises. Legislative and executive interference. Legislative constraints, laws and regulations that may limit judicial independence. Examples of legislative attempts to curtail judicial powers. Executive actions, instances where executive actions have directly impacted judicial independence. Notable examples and their implications. By detailing these challenges, the presentation can provide a comprehensive view of the obstacles to judicial independence in India and underline the importance of ongoing reforms and vigilance to maintain a fair and impartial judiciary. Constitutional provisions. Article 50. Article 50 of the Indian Constitution is a part of the directive principles of state policy, specifically aimed at ensuring the independence of the judiciary. It states, "The state shall take steps to separate the judiciary from the executive in the public services of the state." This article mandates the separation of the judiciary from the executive branch of government to prevent any influence or interference, thereby ensuring that judicial decisions are made impartially and independently. This separation is intended to promote a fair and unbiased legal system, strengthening the rule of law and protecting the rights of individuals. Article 50 is located in Part 4 of the Indian Constitution, which deals with the directive principles of state policy. These principles are not enforceable by any court but are considered fundamental in the governance of the country. They aim to create social and economic conditions under which citizens can lead a good life and help establish a welfare state. Historical context and importance. Colonial influence. Before independence, India's judicial system was heavily influenced by the executive, leading to biased and unfair judgments. The framers of the Constitution sought to eliminate this influence to ensure an independent judiciary. Democratic governance. An independent judiciary is a cornerstone of democracy. By separating the judiciary from the executive, Article 50 aims to prevent misuse of power and ensure that justice is administered without any undue influence from the government. Rule of law. The principle of the rule of law asserts that all individuals and institutions, including the state itself, are subject to and accountable under the law. Article 50 strengthens this principle by ensuring that the judiciary operates independently of the executive branch. Implications and implementation. Judicial reforms. Over the years, various judicial reforms have been implemented to align with the spirit of Article 50. This includes the establishment of an independent judicial appointment process and the creation of separate judicial service commissions. Checks and balances. The separation of powers ensures a system of checks and balances, where the judiciary acts as a check on the powers of the executive and legislature, preventing any potential abuse of power. Public trust. An independent judiciary fosters public confidence in the legal system. When the public perceives the judiciary as impartial and free from executive influence, it strengthens trust in the judicial process and the rule of law. Challenges. Implementation lag. Despite the constitutional mandate, complete separation of the judiciary from the executive has faced practical challenges and has been a gradual process. Executive interference. In some instances, there have been allegations of executive interference in judicial appointments and decisions, which undermine the independence envisaged by Article 50. Overall, Article 50 of the Indian Constitution underscores the importance of an independent judiciary as essential for maintaining the rule of law, ensuring justice, and upholding democratic values in the country. Article 124. Article 124 of the Indian Constitution pertains to the establishment and composition of the Supreme Court of India, including the appointment, tenure, and conditions of service for its judges. Here's a summary. Establishment of the Supreme Court. Article 124 subsection 1 states that there shall be a Supreme Court of India consisting of a Chief Justice of India, CJI, and other judges as prescribed by Parliament. Appointment of judges. Article 124 subsection 2 outlines the process for appointing judges of the Supreme Court. The CJI and other judges are appointed by the President of India. The CJI is appointed after consultation with other judges of the Supreme Court in high courts, as deemed necessary. Other Supreme Court judges are appointed by the President in consultation with the CJI. Qualifications for judges. Article 124 subsection 3 specifies the qualifications required to be appointed as a judge of the Supreme Court. A person must be a citizen of India, a judge of one or more high courts for at least 5 years, an advocate of a high court or multiple high courts for at least 10 years, a distinguished jurist, in the opinion of the President. Tenure of judges. Article 124 subsections 4 and 5 provide for the tenure of judges. A judge of the Supreme Court holds office until the age of 65 years. A judge may be removed from office by the President based on proven misbehavior or incapacity, after a formal process involving an address by Parliament. Oath of office. Article 124 subsections 6 and 7 require every judge of the Supreme Court to take an oath or affirmation before entering upon their office. Salaries and allowances. Article 124 subsection 8 stipulates that the salaries, allowances, privileges, and pension of the judges are determined by Parliament and cannot be varied to their disadvantage after their appointment. Article 124 forms the foundation for the functioning of the highest judicial authority in India, ensuring its independence and integrity. Article 217. Article 217 of the Indian Constitution deals with the appointment, tenure, and conditions of service of judges of the high courts in India. Here is a summary of its main provisions. Appointment. The President of India appoints every judge of a high court. This appointment is made after consultation with the Chief Justice of India, the Governor of the state, and, in the case of the appointment of a judge other than the Chief Justice, the Chief Justice of the High Court. Tenure. A judge of a high court may hold office till he/she attains the age of 62 years. 3. Resignation and removal. A judge may resign by writing to the President. A judge can be removed from office by the President on the grounds of proven misbehavior or incapacity. The removal process involves a motion passed by each House of Parliament with a special majority, 2/3 of the members present and voting, and a majority of the total membership of the House. Conditions of service. The Parliament may by law regulate the procedure for the investigation and proof of misbehavior or incapacity of a judge. Judges' salaries, allowances, privileges, leave, and pension are determined by Parliament by law, and cannot be varied to their disadvantage after appointment. Transfer. The President can transfer a judge from one high court to another after consulting the Chief Justice of India. Article 217 ensures that the process of appointing and removing high court judges is structured to maintain judicial independence and integrity. Article 233. Article 233 deals with the appointment of district judges. Here is a summary. Appointment of district judges. The appointments, postings, and promotions of district judges in any state are made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. Eligibility. A person must be in the judicial service of the state or must have been an advocate or pleader for not less than 7 years to be eligible for appointment as a district judge. The High Court must also recommend the candidate. Article 233 ensures that the process of appointing district judges maintains a balance between the executive and judicial branches, promoting merit and judicial independence. Measures to strengthen judicial independence. Transparent appointment process. Reforming the collegium system. Implementing a more transparent and accountable system for the appointment and transfer of judges. Proposals for a judicial appointments commission or similar bodies to ensure merit-based appointments. Public scrutiny, enhancing the transparency of the appointment process by involving public and expert scrutiny. Publishing the criteria and reasons for the selection of judges. To judicial accountability. Judicial performance evaluation. Establishing regular performance evaluations for judges based on objective criteria. Incorporating peer reviews and feedback from legal practitioners. Judicial conduct codes. Strengthening and enforcing codes of conduct for judges to ensure ethical behavior. Creating a robust mechanism to address complaints against judges while protecting their independence. Independent oversight. Forming independent bodies to oversee judicial conduct and address grievances without political interference. Ensuring these bodies have adequate powers and resources to function effectively. Three, infrastructure development. Modernizing court infrastructure. Investing in modern court facilities, including adequate courtroom space, technology, and amenities. Ensuring all levels of courts, especially lower courts, have sufficient resources. Technological integration, expanding e-court initiatives to streamline case management and reduce delays. Implementing online case filing, virtual hearings, and digital case tracking systems. Resource allocation, ensuring sufficient financial and human resources are allocated to the judiciary. Addressing disparities in resource distribution among different regions and levels of the judiciary. Reducing case backlogs. Alternative dispute resolution, ADR. Promoting the use of ADR mechanisms like arbitration, mediation, and conciliation to reduce the burden on courts. Establishing ADR centers and providing training for mediators and arbitrators. Fast-track courts. Setting up more fast-track courts to handle specific types of cases, such as commercial disputes, family matters, and criminal cases. Ensuring these courts are adequately staffed and equipped. Judicial reforms. Implementing procedural reforms to expedite case processing. Simplifying procedural laws and reducing unnecessary adjournments. 5. Enhancing judicial training and education. Continuing legal education. Providing ongoing training and education programs for judges to keep them updated on legal developments and best practices. Establishing dedicated judicial academies for comprehensive training. Specialized training. Offering specialized training in areas such as cyber law, intellectual property, and international law to handle complex cases effectively. Judicial exchanges. Facilitating exchanges and collaborations with judiciaries of other countries to learn from best practices and innovations. Six, strengthening legal frameworks. Constitutional amendments. Making necessary amendments to the Constitution to reinforce judicial independence. Clarifying provisions related to the separation of powers and judicial review. Legislative support. Enacting laws that support judicial independence and protect judges from undue influence. Ensuring laws provide clear guidelines for judicial appointments, conduct, and accountability. 7. Public awareness and engagement. Promoting legal literacy. Educating the public about the role and importance of judicial independence. Conducting awareness campaigns to foster public support for an independent judiciary. Encouraging civic participation. Involving civil society organizations and the public in discussions about judicial reforms. Encouraging public interest litigation to address systemic issues affecting judicial independence. 8 International best practices. Adopting global standards. Learning from and adopting best practices from judiciaries around the world. Participating in international judicial forums and networks to exchange knowledge and experiences. Compliance with international norms. Ensuring that domestic judicial practices comply with international standards and norms for judicial independence. By outlining these measures, the presentation can highlight the steps necessary to strengthen judicial independence in India and ensure a fair and impartial judiciary that upholds the rule of law. Conclusion. Abstract. This document provides a basic understanding of the Indian judicial system, its structure, workings, and key aspects such as the Supreme Court, independence of the judiciary, judicial review, and related reforms. Judiciary. The Indian judiciary is a hierarchical system with the Supreme Court at the top, followed by high courts at the state level, and subordinate courts like district and magistrate courts at the district level. It is known for its independence, with judges appointed through a rigorous process to ensure impartiality and integrity. The Supreme Court of India has original, appellate, and advisory jurisdiction. High courts oversee states or groups of states, while subordinate courts handle district-level cases. The judiciary is proactive in protecting fundamental rights and ensuring social justice through judicial activism and public interest litigation. Challenges include a backlog of cases, which leads to delays in justice dispensation. Efforts like court modernization and increasing the number of judges are ongoing to address this. Adoption of technology, such as e-courts and online case management systems, is being gradually implemented to streamline processes and improve access to justice. Discussions and reforms related to judge appointments, accountability, and judicial activism continue to enhance the judiciary's efficiency and effectiveness. Supreme Court of India. The Supreme Court is the highest court in India, ensuring the supremacy of the Constitution and resolving disputes between the center and states. It consists of a Chief Justice and 33 other judges, appointed by the President after consultation with judges of the Supreme and High Courts. Judges hold office until the age of 65 and can only be removed by the President on grounds of proven misbehavior or incapacity. The Supreme Court has original jurisdiction in disputes involving the Government of India and states, and appellate jurisdiction in civil, criminal, and constitutional matters. It also has advisory functions, where the President can seek the court's opinion on legal questions of public importance. The court can issue directions, orders, or writs to enforce fundamental rights and has the power to review its judgments and orders. Public interest litigation allows individuals or organizations to file cases on behalf of those whose rights are violated, ensuring access to justice for the underprivileged. Public interest litigation and judicial activism. Public interest litigations have been instrumental in expanding access to justice, allowing public-spirited individuals to seek judicial redress for those unable to approach the court themselves. The doctrine of locus standi has been broadened to include cases filed in the public interest. Landmark cases like S.P. Gupta v. Union of India and Husainara Khatun v. State of Bihar have highlighted the impact of public interest litigations in addressing issues like prison conditions and under-trial prisoners' rights. The Supreme Court has developed compensatory jurisprudence to provide relief to victims of justice system abuses. Overall, the Indian judiciary plays a crucial role in upholding justice, equality, and the rule of law, despite facing challenges such as case backlogs and the need for ongoing reforms. Like, share, subscribe and comment your views.